Guess what? Disney is at it again with another crazy lawsuit. This time, it's about a wrongful death suit regarding somebody who died from severe allergic reactions to food that they ate at a Disney restaurant. But Disney is now trying to say that their fine print does not allow for the wrongful death claim to be pursued in court, but must go through arbitration first. And solely arbitration, meaning no judge or jury would make the decision, but rather a paid arbiter would. Here's the thing. Disputes like this can arise in any industry, and the photography and wedding industry is no exception because there are contractual disagreements and client dissatisfaction up the wazoo, and conflicts escalate quickly. So in this episode, I'm going to talk about the art of resolving those disputes outside of court, particularly through arbitration and mediation, and whether those are good or bad clauses to have in your contract or to agree to as a consumer when you sign contracts all the time online. Sound intriguing? Let's talk about it. Hey there, I'm Paige Griffith, your host and an attorney for small business owners. I help online businesses and creatives get legally legit in no time. This podcast is all about the legal and the Paige behind it. I'll break down and simplify legal talk while providing practical business guidance every step of the way. And after over a decade in the entrepreneur space and becoming a mother, I'll also be sprinkling in tips for running a business and giving you a glimpse behind the scenes of what life's really like. As a gentle reminder and disclaimer, I am an attorney, but I am not your attorney. So be sure to seek legal counsel for personalized advice. Welcome to the Legal Paige Podcast. All right, so have you ever subscribed to a free trial of a streaming service and not even read the fine print? Anyone raising their hand? Yeah, me too. I think we all have. And Disney has gotten into this scandal right now, trying to use an arbitration clause in a terms and conditions for Disney Plus in relation to a wrongful death suit that was on Disney property in person. I'm sure you're like, wait, what? All right. Here's the story. So a doctor and his wife were eating at a restaurant at Disney Springs. Disney Springs is outside of a Disney park, but it's still an area owned by Disney. And this restaurant was not a Disney restaurant. It was a different business as a whole, but still on Disney property. Although the doctor had expressed while eating at this restaurant that he was allergic to nuts and dairy, he was apparently served food with nuts or dairy in it, or the meal had touched it, and massive severe allergic reactions and died as a result. Like, oh my gosh, terrible, terrible. But the lawsuit as a whole is now being brought by the widow, and they're claiming wrongful death against Disney in court, and they asked for a jury trial. But Disney's legal counsel, super smart here and definitely trying to get around a jury trial, is arguing that because the doctor at one time signed up for Disney Plus for a free trial, that within the terms and conditions of Disney Plus, there was an arbitration clause in there. And now the doctor and the heirs of the doctor, which is the widow who's bringing this claim in court, is bound by a very small arbitration clause in the Disney Plus terms and conditions. Like, seriously? Okay, so no surprise that this got picked up, national attention, bad PR for Disney, and Disney has now backtracked their legal counsel's stance due to the backlash. I'm sure Disney's PR team got heavily involved. And they are retracting their statement that this couldn't be in court, that it has to be bound by arbitration and this weird clause in a Disney Plus, like online contract that they signed. They were in person at Disney Springs, yada, yada. The wrongful death claim has not been resolved yet, but they backed off on trying to enforce an arbitration clause here. However, all of us as business owners and people in general are like, can that actually be legitimately enforced, though? An arbitration and mediation clause in a terms and conditions, if someone were to file suit in court and ask for a bench trial, which would be a judge deciding, or a jury trial, which would obviously be a jury deciding. Really, though, like, how do mediation and arbitration clauses work? Why are they in contracts? Are they valid in contracts all the time? How do you enforce them? Are they really helpful to you as a business owner and to the client and consumer? And really, should you, as a service-based business owner who's listening to this podcast, actually have an arbitration clause in your client contract? Or should it be a mediation clause? Or should you just have a venue and jurisdiction clause? What are those clauses? So a brief overview of what arbitration and mediation even is. Why are these things important? So trial is very, very, very costly, like a jury trial and a bench trial. When you're in the courtroom and you have attorneys representing you and you're arguing back and forth and you're presenting evidence and you put people on the stand and you're asking a jury essentially to decide this matter for you. Jury trials are fun to watch on TV, but they're typically very, very fickle, hard to control, right? It's lay people. And the same goes with judges for a bench trial. Judges have a little bit more expertise in the law, but they're still humans and sometimes decide things very randomly and without a whole lot of legal backing. So really in civil suits like this, we're not talking about criminal law, we're talking about civil law. In civil suits, many businesses have arbitration and mediation clauses in their contracts. And that is in order to expedite issues and save money. And also helps cut out that ambiguity that a jury or a judge would bring because you're talking about humans deciding the ultimate decision on a case versus an arbiter. And we'll get into that in a little bit. So what is arbitration? What is mediation? Arbitration, they're two very different things. Arbitration is a more formal process where the disputing party presents their case to one or more arbiters who act like private judges. So usually the parties pick their own preferred arbiter and the parties then agree to arbitration and that specific arbiter. And the arbiters then listen to both sides. They review evidence. They kind of look at the laws and they make a binding legal decision that all parties agree to. Mediation is a less formal process. It's a neutral third party. This is, again, chosen in agreement by the parties. So really, you have a lot of say with mediation and arbitration. You still do with mediation. And then a mediator would facilitate really a discussion between everyone. And they're just trying to negotiate a mutually acceptable agreement and resolution. A mediator does not make decisions, but guides the conversation, definitely acts as a third party here. And the goal of mediation is for both parties to sign a settlement agreement. So the mediator isn't deciding it and having a binding legal decision, but you're just trying to get the parties to come to their resolution together. So the differences between arbitration and mediation. The formality of the binding decision of arbitration versus more of a collaborative nature of mediation, and that when you are in arbitration, it's binding, the decision is binding, and mediation agreements are oftentimes non-binding. You can sit on a settlement agreement until you sign. You can try to get to as close as possible to a settlement, but then you could leave mediation and one of the parties could want to negotiate the settlement agreement even more. There's just a lot of wonky things with mediation. So here's some situations where each method might be appropriate. If the stakes are lower, aka it's like a lower monetary amount of damages that you're seeking, and the parties are open to coming to an agreement, mediation is truly a great way to come to middle ground. Both parties need to be in a place where they're willing to compromise on something in order to make mediation work, but it happens every day, all the time in the legal world. Arbitration, though, is a good fit for those who want a more expedited litigation process. They don't want to go to trial, but they still want a binding legal decision. And keep in mind here that arbitration can be more expensive than mediation, but the decision can't be appealed. And arbitration is basically just binding. That's it. That at the end of the day, that's what it's going to be. And the good news is an arbitration proceeding can also be kept confidential, which is really good for a lot of businesses and consumers and clients. They want the decision to be kept out of the courts and not in the public eye. I want to talk for a second about common disputes that you would see in kind of the service provider industry, photography industry, wedding and event industry, if you're an online service provider as well. So contractual disagreements, so scope of work, deliverables, timelines, client dissatisfaction, so quality of photos, editing issues, unmet expectations, payment disputes, so non-payment, refunds, deposits, lack of services, undelivered products or undelivered photos or videos or, whatever the deliverables are going to be. In intellectual property issues, so usage rights, unauthorized use of images, so on and so forth. These common disputes impact both not only you as the company and the vendor servicing the client, but they also affect the client too. The clients don't want to have to deal with more time and more emotional turmoil, and definitely not more of an expense than they already are dealing with working with a service provider. And you as a service provider don't want to lose out on money if you believe the dispute is actually more in favor of you. So there's a lot of benefits here of using arbitration and mediation. Advantages of arbitration is, like I mentioned, faster resolution compared to court litigation, privacy and confidentiality, and it's a binding decision. And this will ultimately just reduce any type of prolonged dispute. So you want to resolve things as quickly and efficiently as possible, move on in your business journey, and your clients want to as well. If they think they're in the right, then going to binding arbitration may actually serve them better. Advantages of mediation is it's kind of more of open communication and collaboration, but sometimes when you're just in like really sticky situations with your clients, you don't want to do that. You don't want open communication. That's too many emotions at play, and you just want an arbiter to decide it and look at the law and look at the evidence and provide a final decision. But mediation also kind of sometimes helps maintain your professional relationship with your clients or clients. If you need an open dialogue, then mediation might be the best course of action for you, because maybe this person's going to continue to refer, and that you guys, I don't know, maybe not continue to refer, right? Because you're in a dispute, but you just don't want to leave on like completely bad terms, like going to court. Arbitration's like in the middle of mediation and court, if that makes sense. And mediation is honestly usually more cost effective than arbitration. The problem is mediation's non-binding. So you can get creative with your solutions, but even if you try to settle something at mediation, it can still go to court after. So there could be wasted efforts. What I want you to do as your friendly online attorney is to incorporate arbitration and or a mediation clause in your contract. You need clear dispute resolution clauses in your contract. So you need either an arbitration clause or a mediation clause. I don't want you to have both. Usually it's going to be an arbitration clause. It's going to have a clear definition within that clause of the arbitration process to be used. It'll specify kind of the rules of arbitration or the cost of arbitration and payment responsibilities between the parties. Usually that is cut equally between the parties. And then it'll also say the location and jurisdiction details. Then, of course, dispute resolution clauses would first be, okay, this is an alternative dispute resolution. We're going through arbitration. Maybe it's a mediation clause. You may see that in contracts. But the legal page uses arbitration clauses. But then, of course, if you don't come to a resolution with arbitration for whatever reason, then venue and jurisdiction could be handled in court, and the venue jurisdiction clause would then apply. So those two are usually next to each other at the bottom of your contracts in your general provisions, or boilerplate language, as I like to call it. Ultimately, I think that including an arbitration clause in your service contract really just provides you peace of mind by ensuring that any disputes will be handled efficiently, fairly, and privately, which protects your business interests, but it also protects your clients as well. So again, here, I want to reiterate that having an arbitration clause in a service-based contract with a client is important for all of the reasons that I've quoted: cost-effective dispute resolution, confidentiality, expert decision-making, flexibility and control, finality of decisions, and preserving your business relationships, making it kind of less adversarial overall. It's binding outcomes. Yeah, the arbitrators in arbitration are chosen based on their expertise in a specific field, meaning that they can better understand and really evaluate the nuances of the contractual dispute as compared to kind of a general court judge. And there's lots of flexibility with arbitration in terms of scheduling and procedural rules. You can oftentimes do Zoom arbitration, and so that gives a lot of the control to the parties on how the dispute is going to be resolved. And you get the choice of arbitrator. So you don't have to just like hope and cross your fingers that you're going to get the right judge or jury. Now, I want to give my reactions to the Disney case here. So does this arbitration clause in Disney Plus stand here, or does this person really have a right to a jury trial? So even if Disney would not have gone back on this stance, I honestly doubt a court would have held up this request by Disney and this motion for binding arbitration. First, this lawsuit really had nothing to do with being a participant in the Disney park or watching the Disney Plus streaming service. The claim only had to do with the wrongful death that occurred in person at Disney Springs at a restaurant, an independently owned restaurant at that. And although the terms and conditions of their Disney Plus agreement may have stated that it applies to all Disney properties and anything that you may do with Disney, it's unlikely that a court would rule that that has a general sweeping approach and that terms would apply to eating at a restaurant in Disney Springs. Sometimes lawyers get crafty and contractual lawyers will say, okay, I want this clause to be extremely broad, but then a judge will narrow the clause back down and be like, no, you should not have written it like that. Like, good try, but it's not going to work for a wrongful death claim that happened in person. But really, how should Disney have handled this and what can they do moving forward? I want to just talk about like arbitrations clauses here and various consent forms that may be signed by mainstream people. Like, can those actually hold up? We're constantly agreeing to terms and conditions with streaming services that we use as consumers. So although I don't think an arbitration clause in this scenario would have necessarily held up in court, I'm not saying that all arbitration clauses won't hold up. Actually, it's kind of the opposite. There's a long history of arbitration clauses in terms and conditions within contracts being held up, mandating that the issue be thrown out of court and transferred to arbitration. And especially in the service-based industry, when you as a business owner and the client or customer is agreeing to XYZ services, they're signing a very lengthy contract. It's less of a click wrap agreement where you're checking a box online. That would happen here with the streaming service. You're actually doing a signature online. You're actually signing a document. That will make an arbitration clause hold up way more because the parties are mutually agreeing to alternative dispute resolution versus like a passive, was there a meeting of the minds with that click wrap agreement and that streaming service agreement? And did the consumer actually know what they were agreeing to? You have a lot of those arguments on your side when you have an arbitration clause in your contract, which is why I always suggest it. Truly just for efficiency's sake, time's sake, and money's sake. Now, your head may be spinning a little bit, talking about arbitration, mediation, venue, and jurisdiction. It's the land I live in the legal world and contractual world, but it's probably not something that you want to think about or talk about. So thanks for at least sticking with me as we discuss this issue. The Disney case is really just a wild reminder of how crucial it is to understand the fine print that you're agreeing to, whether you're a business owner or a consumer. And dispute resolution clauses like arbitration and mediation really can significantly impact how conflicts are handled. And so you need to know when and how to use them in your contracts to save you all the headaches that you may have down the road. Remember, while arbitration can offer a faster, more private resolution and more efficient resolution in terms of monetary wise, it's not always the right choice in every situation. We have them in our service-based contracts for a very specific reason, but you could also change that out to mediation to help preserve relationships and foster collaboration. But arbitration and mediation both require the parties to be willing to find common ground. And so I really like those clauses in the contracts so that you're not immediately going to be sued in small claims court or in actual state court or even in federal court, that you're going to an alternative way to resolve the dispute first before you head to something that's you're going to be bleeding money and bleeding time and bleeding emotionally. That's what we call it in the legal world, going to court. So as always, make sure your contracts are clear, fair, and reviewed by a legal professional to ensure that you are protected. So if today's discussion has sparked any questions for you about your contracts or your dispute resolution options or whether your arbitration clause is legitimate or not, maybe you don't have a legal Paige contract, you just have an existing contract and you're going to go look at your general provisions now and see what it says about arbitration and mediation, please feel free to reach out to us. You can ask questions in a general forum at the Legal Paige community on Facebook. You can also reach out to my law firm if you want to jump on a consultation to discuss this or to maybe go through your contract. We offer those legal services as well with one-on-one clients. I'll make sure to put that in this episode's description for you so you can easily find us. And if you found this episode helpful, remember, I would love for you to share it with your network and your friends and business owners. There's always more where this came from as well. Until next time, stay legally legit and keep those contracts airtight, my friend. Thank you so much for tuning in to today's show. Be sure to visit thelegalpage.com for contract templates, blogs, YouTube videos, and additional legal resources. If you haven't already, head over to iTunes and leave me a review and rating. It truly means so much to me to hear your feedback and inspires me to continue creating podcast content. Also, I want to personally invite you to my free Facebook group at tlpfacebook.com, where you will get access to me, my legal team, and thousands of other entrepreneurs in there for unlimited business and legal Q&A. Until next time, my friend.